So welcome, everyone. And I'm just so pleased that there is, tremendous participation in terms of, attendance at this symposium, which is covering just, I think some of these really important, entrenched, old issues, and then also introducing, new reforms, but doing so in a critical way. It's already gotten off to such a strong start with respect to that, and I know that we're going to keep doing that now, and and continuing into tomorrow. And so this panel, this housing equity panel, is going to dig deeper into some of the housing equity issues that were already foreshadowed previously, and I just wanted to give even a little bit more background about the important issue of housing equity, or as I often call it, housing justice. So one of the things is, the role of, so many government laws and, government programs and federal and state laws, but also of zoning in particular in segregating and oppressing, communities of color, immigrant communities, and the very low income communities. And so this here, I can commend a report by the city of Portland on the historical context of racist planning in Portland. One of the things that I note, I personally have not yet been able to find, and if anyone in the audience has found it, please reach out. I haven't been able to find anything in the record that shows that the first zoning code of Portland designated, the single family, low density areas intentionally to further segregation. But I do note that the first zoning code of Portland was adopted, I believe it was in 1921, and this picture here on the screen is showing, a number of Portland dignitaries, posing and unabashedly, with the Ku Klux Klan. Another housing justice issue that I just want to point out to is, the issue of environmental justice and of disaster resilience as we're facing, a changing climate. Here's a picture of Vanport, Oregon, which Oregonians will be familiar with, but others may not. This was an area adjacent to the city of Portland, where there was really an established Black community, but as is the case in so many jurisdictions, that land area where this community was really pushed into, and concentrated in as a government policy, was undesirable land by the politically powerful white and high income community. Why? Because it was subject to a lot of flooding, as shown in this picture, which just devastated this community. After this flood, and this is a picture from 1948, after this flood, the community was then, by government policy, concentrated in an area of Portland known as Albina, which thrived and became a cultural hub. But Albina was later deemed by the city to be, so blighted that despite the residents' requests for grant funding to improve the area that was this cultural hub of Portland and really where most Black citizens in Portland lived, the area was deemed to be blighted, was raised, and to make room for freeways and stadiums and a hospital and other things. So this is part of why we talk about, housing justice and housing equity, and part of why we have so much work to do, right? And I just wanted to not pick on Portland, and also just highlight where I live now, which is Eugene, Oregon. Eugene, Oregon, there was an established and, thriving within the context of its circumstance, Black community early in the history of Eugene, Oregon. It wasn't in the city proper, because of decision making that was occurring and programs, policy of the city. but instead was right adjacent to the city where city services weren't offered in this area known as the Ferry Street Bridge neighborhood, until that became an area that the city, wanted. And then with minimal notice, bulldozers came in and, raised that whole community. Looking back, oftentimes that community is now referred to as having been a tent city, giving the implication that they could just fold up their tents and move, but it wasn't in fact an established community. So that population was pushed into an area of Eugene and West Eugene, where there is, if you see here, this purple designation as heavy industrial. And, now, an area of significant environmental justice concern, this one West Eugene zip code having 99.9 to 100% of the total toxic emissions in Eugene. Because if you compare it over here to all other zip codes in Eugene, 0.1%, 0%, 0.1% based on which year. And there has been a EJ action and really phenomenal work of advocates. And with that, I really want to transition to introducing, one of the, an advocate in Oregon who I've seen in action and really been impressed by. And that is one of our speakers for today, Allan Lazo. He's the executive director of the Fair Housing Council of Oregon. I just want to plug the Fair Housing Council of Oregon. Also, the mission of that organization, as it says on the screen, is to end housing discrimination in Oregon through access to education, advocacy, and enforcement. And they do powerful work. They show up. I got to know Allan through his work on the Rulemaking Advisory Committee on Oregon's new housing laws that just resulted in regulations implementing those laws. He is a longtime community advocate for civil rights and social justice, especially in the areas of housing, houselessness, racial equity, and racial justice. And he has served on numerous boards and committees, and including the City of Portland's Housing Bureau's Affordable Housing Bend Oversight Committee. He served, like I said, on that Rulemaking Advisory Committee I was just referencing. And as a member and a chair of Portland's Human Rights Commission. And I'm cutting his bio short just because I know you want to get to the substance. We also are, I think, really lucky today to have Commissioner Anyeley Hallová, with us today, a commissioner on Oregon's Land Conservation and Development Commission, which is a governor-appointed position. She's also appointed by the mayor to Portland's Adjustment Committee and to the Community Involvement Committee for the Portland Plan, Policy Expert Group for Residential Development and Compatibility for the Comp Plan. She's got extensive experience as a sustainability-focused real estate director. She has served on the board of 1,000 Friends of Oregon, speaking again of powerful advocacy. Portland's Housing Center, the Seoul District. She's an expert on Urban Land Institute advisory service panels. She's a published researcher and writer. And I had the honor really to serve on the Rulemaking Advisory Committee for the middle housing and housing needs analysis laws just last year, and really got to see her commitment to housing justice in action. And then we also have as a panelist, Judge Peter Bucksbaum. Judge Bucksbaum was appointed as a judge of the Superior Court in New Jersey in 2004 and reappointed in 2011. He retired in 2013, but then he was recalled to the bench part-time from 2013 to 2016, during which time he was assigned as the Mount Laurel judge for the vicinage 13. And he also has practiced in a large private law firm. He has been a municipal attorney. He has been on land use boards. He has been active in advocacy organizations also throughout his life. And, you know, he just is incredibly knowledgeable through experience, you know, regarding Mount Laurel and the Mount Laurel Doctrine. And I just have to say here, I also want to mention that I have gotten to know Judge Bucksbaum personally over many years through the American Bar Association, State and Local Government Law Land Use Committee, which has members throughout the country who are focused on housing issues, housing justice from a land use law perspective. You know, I really commend that organization, the ABA State and Local Government Law Section, as a place where you can meet and network nationally and do some great work in this area as well. And with that, I'm going to turn it over to Allan Lazo.
Great, thank you, Professor Schoen. Appreciate the introduction and the slides that you brought forward and the information you brought forward. I very often come into these panels and have that section of work to provide, but I actually wasn't planning that today. So I'm so delighted that you were able to bring those concepts forward. I just want to confirm for folks that you can hear me okay first. And I'm going to assume that that's a yes. I'm also going to start sharing my screen here.
Yes, Allan.
Thank you. Let me figure out where I can do that. All right, there it is. Let me share my screen here with you all. How does that look for you, everybody? All right. So as I said, I really appreciate this framing also around kind of moving from talking about concepts around really backing up to equality and talking about equity, but really moving towards this concept around justice. And I want to make sure that I define some of those terms in the way that I'm thinking about them today or using them. So when I think about talking about equality, I think of that as a concept that is especially ingrained under the law. When we talk about equity, I like to think of equity as those outcomes, and particularly outcomes that are not predetermined by parts of our identities or other characteristics, such as where we live, right? So when we think about and talk about racial equity, what I'm talking about is that we have outcomes that are not determined by our social identity around race. And finally, when we talk about justice, that is that broader piece around an action or a set of actions that are rooted then in those concepts of equality and strive for those outcomes of equity. So it really sort of becomes that action piece, that last piece in what we are looking to achieve as we're working towards housing justice. So whoops, let me back up one. Oh, well, I'll leave it there. So I also should note that when I get invited to speak on panels, sometimes I don't tell folks until after they've confirmed that it's okay for me to speak. But I'm actually a guy who has more questions than actual answers. So you can expect that from me here this morning as I move through this. I jumped over to this slide because I wanted to let you know that the way I've thought about this presentation this morning and the title that I'm using is actually that moving from equality to equity to justice. What the search for little green men and the quest for housing justice should have in common. So as you see on the screen here, I've always had this sort of fascination with UFOs, and one of my favorite movies is actually the movie Contact, there on the right, with Jodie Foster and Matthew McConaughey. It's also based on the book by Carl Sagan and his wife, also by the name Contact. So the movie, in addition to being based on the book by Dr. Sagan, tells in part the real life story of Dr. Jill Tarter, who ran the SETI project. And for folks who may not be familiar with that, SETI is the search for extraterrestrial intelligence, the scientific search for aliens. I actually had a chance to meet Dr. Tarter, and by meet, I mean she signed a copy of her book, Making Contact, after she spoke at my local astronomy club meeting here in Portland. That probably wasn't the sentence that you were expecting to hear this morning at the symposium. And I know it's a lot to unpack in one sentence, but I'm just going to leave all of that right there and move on to talk about the importance of what Dr. Tarter had to say about their search for extraterrestrial life. one of the things she talked about was in their work at SETI, one of the ways that scientists patterned their searches was first to imagine what life might look like for a world or society that actually may have evolved differently from ours. And then in their search, to look for the signatures of that possible world throughout the universe. One of the examples that Dr. Carter gave was to say that part of her job was to think about these possibilities, what these possible worlds might be like. She said an example of that was thinking about a very advanced civilization that might have evolved to using hydrogen as an energy source. So that you wouldn't be looking for a signature necessarily that was based on carbon dioxide as an energy, as the output from energy source, but some form of hydrogen output. She said that would really change the way you searched. So you needed to reimagine what the world would look like before you could actually find it or find a solution to finding it. Now, I'll say that one of the reasons I brought this example forward was in part because I didn't think I would ever get to use the words Jodie Foster and Matthew McConaughey in one of my panels, so I wanted to be sure that I could do that this morning. But the real important part of that is that it seemed like a remarkable shift in thinking to me. It wasn't that these very smart scientists searched for life based on assumptions that the only way that life could exist in other parts of the universe was the way that it existed for us today on Earth. They worked from an assumption that life could have evolved and could exist very differently. And for them to be able to find and identify that life, they needed first to imagine what life might look like and then go out and look for signs of it. So as I said, even though these scientists spent their entire careers searching for little green men, which, as the movie Contact kind of alluded to, may have been derided as outside the norms of the scientific community, these scientists are very smart people. So it seemed like a really important hypothesis for me, for those of us that are searching for housing justice. Our search for housing justice tends to be based on finding solutions that are rooted in what life looks like right now, here on Earth, and specifically here in the US, and even more specifically in what access to housing looks like today and how it's been normalized. But what if this world that we know, if life that we know had evolved differently, and the signatures of that life could have been or would have been very different? Would we actually be able to see it if we didn't know what it was we were actually looking for? When we think about, as Professor Schoen said in the beginning of this, when we think about what the world of housing access looks like right now, it's rooted in what we think of as the American dream. That is so tied to the history of racial segregation and discrimination that Richard Rothstein is going to talk to us more about at lunch today, right? When we think back to the, for instance, original intentions of single-family residential zoning and its desire to exclude by race, and the evolution that has had to what we call the American dream today. As Richard Rothstein will remind us at lunch and in his book, The Color of Law, before communities evolved that way, cities and communities originally often were on paths to develop as integrated communities before government policies worked so hard to racially segregate neighborhoods. So without those policies, is it possible that life as we know it, as we perceive it in the world of access to housing, would have evolved very differently? And if it had, would we recognize it if we were searching for those solutions that we often strive for, especially for us in the fair housing movement? As an advocate in that movement, this then becomes a call-in for folks here today to move along that spectrum of equality and equity toward housing justice by broadening the way we think about solutions. So today I'm going to spend part of my time before we switch over to other panelists talking about some of the efforts that we go through in looking for housing justice solutions and where we see that they may or may not be finding justice. The two examples I'm going to talk through are race-based preference policies, and I'm going to talk about those from a non-attorney perspective. So I know we've got a lot of folks in the legal field here today. I am not one of those folks. And I'm also going to talk about some examples that are framed around ending racially exclusionary zoning. And similarly, I'm going to talk about those not from a non-planner perspective, because I'm also not a planner. Like I said, I am just a guy who asks a lot of questions. So let's talk about a few of these examples of how we might shift conversations with that broader perspective. So again, it's really looking at what justice might look like if we were rooted in a broader vision of what the way the world would have developed. One of those frameworks is if we look at finding justice through race-based preferences, which again, when we talk about an equality framework, can be very, very difficult to attain. In the work we do in fair housing, we know, for instance, that two-sided protected classes, such as race, don't very often offer us the opportunity to bring forward race-based policies. We have seen some of those. This is a Shelter Force article that talked about some of the difficulties, both legally as well as, I would say, politically or culturally, in bringing forward race-based preferences. And so those are all considerations, I think, when we talk about the opportunity for race-based preferences. There are some examples. And they're going to talk about two different forms of race-based preferences. Some of them are that have passed legal muster more, are actually more narrowly tailored. So one of those is up in Seattle in the Central District there, an area that had been a predominantly African-American and communities of color that is quickly being gentrified, and those communities are being involuntarily economically displaced. So they put in a preference policy around allowing residents in place to have first preference as new housing was coming online. So I've seen the legal research of that. It is framed very, very narrowly around the around not further segregating communities based on preferences. So it threads this very, very narrow legal needle. And so that's one of the frameworks for race-based preference policies, is narrowly focusing them. And I'm going to leave that to all of the attorneys out there to work through. I just want to bring forward a few examples in places, and I won't, I'm not going to touch on whether or not they are legal or are operating well, but just examples that are out there. Another one that exists is actually right here where we are in Portland. So here in Portland, there's a preference for housing in North and Northeast Portland, an area that was a redlined area here in Portland that had been a predominantly Black community up until the early part of the 20th century, when gentrification came to that area and economically or involuntarily economically displaced much of the Black community that was there. So a preference policy was put in place there that also, again, is very narrowly focused. And it's interesting, in this preference policy, there was a government or an institutional action related to a hospital there that was going to do an expansion and displaced a number of residents, including through eminent domain. So they actually took property from some residents. So the way this preference policy is framed is actually higher preference for folks who were closest to those government actions for the hospital. So that's actually the way this preference policy map works. There's a scoring system that is based on the harm that you or your family had experienced in this area, and you get a set of points based on that relative closeness to that harm, that then preferences you on waiting lists for affordable housing or home ownership in these neighborhoods. So again, it's really interesting to think about, if we ask the question, are race-based preferences possible? One of my favorite answers, and especially the answers that we have when we talk with attorneys, is it depends. right? So in these cases with Portland and Seattle, they were very narrowly focused and seemed to pass legal muster, at least in the opinion of attorneys who have been working on these pieces. We also know that preference policies can be quite problematic, right? When we compare narrowly tailored solutions like Seattle and Portland to the more broadly focused neighborhood preference policies, policies we see, for instance, in New York and San Francisco, that tend to come under quite a bit of scrutiny around who they might allow in, who they might keep out. So those are really, I think there's a contrast there, and I'm not here to say one is better than the other. You know, housing justice is such a complex issue. It calls for multiple complex solutions. And so any of those that we can find to serve those frontline, most impacted communities are really all the solutions we need. So this is a very broad spectrum of solutions that are moving around that I would encourage folks to, again, broaden thinking about the way we might apply that spectrum of equality, equity, and justice when you're looking for solutions around housing justice. There's a few others that I'll bring in that aren't necessarily housing related. A couple of them are finance related. There's one moving around from our colleagues at the National Fair Housing Alliance related to what are called special purpose credit programs that allow some, and even more so now as we move forward in having an administration that has more liberal or more progressive thinking around financial controls, that there apparently is an opportunity right now to have some discussions about whether or not race-based credit lending, or at least evaluation of banks and their lending, can be race conscious. Similarly, at the National Coalition, Community Reinvestment Coalition, there's some talk about whether or not the Community Reinvestment Act might also be opening up to some of those same conversations about how being race conscious or race-based might play into the evaluation of banks and the way that financial investments are being made in communities. There are a couple outside of the housing world, but related to it, that I think are really interesting too. In this time of great uprising around racial injustice, we've seen this movement and discussion around reparations, especially for the Black and African American communities. And what's so interesting to me in that framework is how many of those conversations are rooted in this history around racial segregation, housing discrimination, and that is really seen as part of the framework for which reparations need to be paid, and the framework for which it comes forward. In North Carolina and Asheville, part of the reparations discussion there was centered around bringing forward those pieces. Oh, 5 minutes there. Ooh, boy. All right, I'm gonna accelerate here. And right here in Oregon, another, again, this faced both a legal and a community challenge when some of the coronavirus funding, the COVID-19 funding that had been intended to go to Black Oregonians was challenged both legally and really from a framework that it was unequal for others who weren't receiving that. So I want to move into the second part of this then and talk about finding justice by ending racially exclusionary land use zoning. And I'll have to leave a lot of this for our discussion later, but there are a couple places that I will touch on this here. And one of those, of course, is what we're going to hear later about the Mount Laurel Doctrine from Judge Buchsbaum, right? This is these opportunities to rethink how we develop communities, the role of affordable housing and who we exclude and who we include in our communities. Right here in Oregon, we also became part of that kind of nationwide movement to end exclusionary single-family residential zoning. We've seen that conversation happen originally in places like Minneapolis. Now we see lately down in Berkeley and Sacramento. And that also is really rooted in this sense of ending this past history of racial exclusion, racial segregation. And so for me, it really becomes, I won't be able to cover all of these, but what I will frame is that I often do say that one of the ways we have this conversation is leading with race there. But the second bullet point there is what's important to me, is that very often when we lead with conversations about race, we aren't able to create intended outcomes that are centered on race. I think we saw that, and I think some of that is for legal reasons. And so I would leave that to the great legal minds out there more to really broaden the perspective on how we might be able to bring those solutions forward as we are working in this area that is so focused on ending exclusion by race and racial segregation. So I'm going to pop through a bunch of slides here that I won't be able to talk through. But again, that framework really is around, how do we really serve these communities through these policies, and that tend to be framed in the beginning around racial exclusion, and very often end up not addressing that very issue. I think one of those places I would say was up here in Portland, and I very often pick on what happened in Portland here, their residential infill project that, that again started out talking about the exclusionary nature of single-family residential zoning, and then they did a displacement risk analysis that actually showed, in some instances, that communities of color might be more impacted, and just slightly more impacted, by these actual developments. And that was shown out here by this this displacement risk analysis that showed that the displacement risk would be reduced for 257 households in certain census tracts that were predominantly lower income or communities of color. But when you broke out those by race, it actually showed that white households would actually see a greater reduction in displacement than the communities of color. So the intention of the policy, as in part, if it was to end that, the impact of displacement on those communities, didn't actually have that intended outcome. And now when this moved through, it had been a very long project. As it moved through, there were some provisions put in place to help remedy that. But again, this was part of that conversation about being very intentional about what our outcomes are. Let me skip through all these folks here. You won't get the benefit of seeing all those, but we'll talk about them later if we get a chance. So the other piece I'll close with is really this piece also, when we talk about ending racially exclusionary land use zoning, is this movement that we just saw in Boston to add fair housing elements to their zoning code. And one of the things that really struck me about what happened in Boston was this sense that it had been so revolutionary that it took us until 2021 to marry fair housing and land use zoning. And that's actually one of the pieces that really struck me. I know that Vice Chair Hallová is also going to talk about HB 2001 and 2003, but the work we did in Oregon here around our regional housing needs analysis, and including in those planning processes, addressing racial equity and fair housing, and how divorced those concepts had been in our land use planning and housing planning system. So I think it's just really interesting to me to think about how long it's taken us to recognize the role that those play in our land use zoning. So as I close here, and I know that I'm probably over a little bit of time, but again, this afternoon at lunch, we're going to hear from Richard Rothstein. And I had the honor of welcoming Richard to Portland in 2018 for the 50th anniversary of the Fair Housing Act. And I never miss an opportunity to either name drop or show my picture. And one of the things that struck me in his book about remedies is when he says, quote, "We might contemplate a remedy like this. Considering that African Americans comprise about 15% of the population of the New York metropolitan area, the federal government should purchase the next 15% of houses that come up for sale in Levittown," right? The exclusionary neighborhoods that were developed in the mid part of the 20th century, for sale in Levittown at today's market rates, approximately $350,000. It should then resell the properties to qualified African Americans for $75,000. The price in today's dollars, he says, that their grandparents would have paid if permitted to do so. Now, Richard readily admits that he's actually not a housing policy person. And he says in the book, he says, I present this not as a practical proposal, but only to illustrate the kind of remedy that we could consider and debate if we disabused ourselves of the de facto segregation myth. So what I'd offer is that by limiting our search for justice based on what we know exists, on what has been created by these systems, we limit what is possible, and more importantly, we limit what we think is possible and what we might be searching for in solutions. And I'll ultimately close by returning to our space theme and another outer space related motto that I think is probably against the nature of lots of the folks in the legal field here, but it is to ask whether we will, quote, boldly go where no man has gone before. So thank you.
Thank you. And I want to just move to Commissioner Hallová, but I also want to remind the audience, the attendees, you can post questions in the Q&A that we'll be able to get to and hear more from the panelists in that way too. So without taking up any more of your time though, Commissioner, and Allan, if you could stop sharing your screen.
Thank you. I am going to switch over here. Take a couple seconds.
And we can see your screen now, Commissioner.
Okay. I'm going to try to do a full screen and see if you can still see it. Are you able to see that? Does it cut off a part of it?
It does. It was full
Okay.
screen a moment ago, though.
Yeah, let's go back. Okay. Thank you for having me. It was so inspirational to hear Allan speak, not only on housing, but also on sci-fi, which is a favorite of mine also. So I really related to that. And so I'm going to go from his very inspirational and also overview to something very technical, I feel like all of a sudden. But really, at the end of the day, it's how do these ideas actually manifest themselves into either land use law, policies, funding, and I'm going to talk about some of the work that we've done in Oregon related to implementation of House Bill 2001 and 2003, which Sarah and Allan were both involved with at some level. And I'll talk more about kind of the process because I think that's important to how these laws and rules get shaped. So House Bill 2001 deals with housing choice, and I'll talk about that more. And House Bill 2003 is about housing needs and production. It was introduced by Representative Tina Kotek. Legislators passed it in 2019, and then the implementation, the rulemaking associated with it came from the Department of Land Conservation and Development. I am the vice chair of the commission over the department, and I was fortunate to be co-chair of the Rules Advisory Committee that helped to shape the rules that came out. So I just wanted to thank all of the legislators that passed that, because without that, we wouldn't have this today. And so why these bills? Obviously, we all know, the ones on the call from Oregon know we have a housing crisis. So the lack of housing families can afford is a problem across Oregon. Many are severely rent burdened, and this keeps on increasing. It's going to be even more so after COVID. There's a need for more housing choices specifically. And really, this housing should serve the needs of all Oregonians, especially those that have been historically marginalized. And so as a commission, we gave a charge to the Rules Advisory Committee. As a developer, I'm a real estate developer, it was really important that the rules came out with clear and objective standards so that it could be easily implemented and people would be able to know what is possible. And then, to provide affordable living choices with access to employment and transportation. And then there's a component of these bills that dealt with phasing of some of the rules due to whether a city had enough infrastructure. And then really adding something that I hear, I've only been on commission for 3 years, but I hear is new in thinking about this, and that's really to strive toward equitable outcomes that benefit people that have not, have been, as Allan pointed out, and Richard Rothstein will talk more, have specifically been kept out of housing and of neighborhoods. So housing choice, House Bill 2001, it aims to provide Oregonians with more housing choices, as we mentioned, but really the affordability has been brought to the forefront. And then really thinking about diverse housing types in all residential neighborhoods. So Allan referred slightly to exclusionary single-family zoning and the idea that now we don't have that in Oregon as a result of these bills. It was a very inclusive process. What was great about it was the diversity of thoughts, interests, backgrounds that came to the table, and I'll show this list for both the House Bill 2001 and 2003. And we were also commingled together, so even folks who were like maybe more interested in how housing gets promoted versus the very technical on the ground, we were all together developing these. And so what's great about this is in the future, all of these folks are going to be seeing this through, whether on the advocacy side or whether on the implementation side. And so House Bill 2001 was, in single family neighborhoods. As a result of this, in cities with 10,000 population or more, must allow duplexes in these areas. And then cities with a 25,000 person population or more should allow essentially what has been dubbed missing middle housing. So triplexes, quads, townhomes, cottage clusters, this type of housing, which was very prevalent, in the 1920s and 30s, but as a result of single family zoning kind of ceased to be built in many areas. Flexibility is allowed with regard to siting and design, but the legislators were very concerned, and we were very concerned that you don't want to create so many barriers that this housing doesn't happen. So this housing should not have any unreasonable cost and delay, especially when compared to single family housing. So it shouldn't be the intent of the rule, and then the actual implementation makes it not happen. So siting standards, might deal with lot size or density or setbacks. They might deal with design, with orientation, the front. And so there was a lot of attention with the group that dealt with this, thinking about how to make these not have unreasonable cost and delay. Obviously, parking was a hot button item. And then, how it got implemented was there was a model code that was developed, which basically if a city just could adopt the model code and be in compliance with the bill. Or there could be some minimum standards. And if the city met the minimum standards, they could have a greater flexibility on how to craft the standards. And really the minimum standards is what cities will be judged on with regard to their compliance to House Bill 2001. And what is the desired outcome of all of this? There's probably 3 points. One is a greater diversity of housing types in formerly exclusionary single-family neighborhoods. Really, this is the way that those neighborhoods would have developed over time if they were not made exclusionary. And if that was the case in the past, we would have mixed income communities, but that wasn't made then. And so we don't have them now. Greater housing choices, the ability to have, a different size, a different scale, depending on your family size, opportunities for infill, smaller footprint of buildings, more sustainable over the long run, especially if you have infill in neighborhoods that are served by transit, next to jobs, you can reduce greenhouse gas emissions as a result. And we're having a climate-friendly rulemaking process right now, and it's very good because we can kind of dovetail those with the housing rulemaking that we did. And then smaller housing types will help to create mixed income communities over time. New housing is not affordable unless it's subsidized in some way, but smaller housing types are more affordable than larger housing types, and over time they would lead to greater mixed income communities. 2001 Housing Choice is really in partnership with 2003, the bill, in order to meet the affordability levels. So House Bill 2003 is Housing Needs and Production. And it essentially requires cities to determine what their housing need is, and determine what their housing need is at various price points, and then develop housing production strategies that promote the development of that housing need. And really, it's housing for all Oregonians at different price points. So this goes more toward the affordability that many would be seeking in the House Bill 2001, but might not necessarily find because that would be mostly new construction. Very inclusive process. Like I said, some overlap with the 2001. And it really required three areas. One was a pilot program that studied the idea of a regional housing needs analysis. We know that a housing market is not a city, right? Because cities have suburbs, cities are connected, certain cities have more jobs than others. And really our state needs to move toward looking at housing regions and not housing per city or by city, and allocating the affordability need in a region, not shoving affordable housing into one city versus, you know, high-end housing into another part. So there's a pilot study. It'd be great if we push that into reality in Oregon. And then there's a housing needs and capacity, like what do we need? In the past, cities have been able to say, let's say we need 1,000 new units, but the question is 100% of that at 30% area median income and below, or is it at a different price point? So kind of finding out what price point you need. And then coming up with strategies, rather than just saying, we need it, let the private development make it happen. Some cities are very active in thinking about how to make it happen, and some cities are not as much. Maybe they don't actually even want affordable housing. This is making cities actually have to deal with the production in their cities. So these are the cities affected by House Bill 2003. And you know, this is kind of the process that it would take. You would have a population forecast, you would project the need, you would figure out if you have the lands enough within your urban growth boundary to build that need, and figure it out by price point, and then you would come up with strategies. And then there's obviously a reflect, a measure, report. Did it actually, the outcome actually happen that you intended at the beginning? The structure of a report that a city has to give to the state deals with coming up with the need, doing engagement in this process, the strategies, and then a new part, which I would say is new to cities, is they're going to have to think about all this housing that you're saying you're needing. Is the outcome going to be fair and equitable? Then they have to conclude, and obviously there's a reporting and review and enforcement and compliance. I put in green the areas that I'm going to talk about today. So contextualize housing needs. Cities have had to do a housing needs analysis before, but this is extending it and kind of addressing more the equitable aspects that we talked about at the beginning. So really creating that thread, kind of like Allan said, between here's our intent and are we going to achieve that intent at the end. So really documenting what are demographic trends, what are barriers to housing, what are the market conditions, and then accounting for groups that haven't been looked at in this way before, by the BIPOC communities, Black, Indigenous, people of color, people experiencing homelessness. There was a lot of conversation about how do we include them, and are they a special class of people? No, they're people that need housing just like anyone else. And really the way to end homelessness is by making housing, folks with disabilities and other protected classes. And then coming up with strategies. And so for each strategy that a city develops, they need to come up with, like, what is it? What's your timeline for adoption? How are you going to implement this? And then what do you think the impact is going to be? Is this impact going to be for affordable housing? Is it going to be for market rate housing? Is it going to displace people? Is it going to address the needs of communities of color? What are the benefits and negatives of this particular strategy you decided to pick? And obviously cities are going to pick a bunch of strategies. And I think when we first came at this issue, it's very easy for planners to think zoning, we're going to change, we're going to upzone, we're going to just very zoning related changes. But really at the end of the day, to make housing happen, there's zoning and code changes. There's reducing regulatory impediments. Obviously, we need money to make this housing happen, most especially at the lower price points. So financial incentives are extremely key. Cities fairly, the feedback that they gave through the process was, we don't actually make housing, and we can't force people to make housing necessarily. And also, if we want to promote housing, we're going to need the resources to do that. So, you know, a list of financial resources. There's tax exemptions and abatements, and then there's a whole host of other things that are more on the creative side, I would say, with land, acquisition, leasing, partnerships. And so the idea behind this chart that you saw was we did a crowdsourced list of strategies, basically asking all the developers, all the planners, all the people engaged in land use, tell us your strategies, whether they exist in Oregon or don't exist in Oregon, whether they're revolutionary or very standard. And we crowdsourced this list. And the idea is that cities can use this as a resource. Also, they can develop their own, they can find new ones and add to this list, and over time this list can grow. And that can make it easier for cities and easier for jurisdictions. And then over time, when cities do their reports and they're reporting back, we can start to see which one of these worked, maybe for a smaller city, maybe for a rural city, and then start to inform each other on best practices. So a thing that the cities have never had to actually address, which is very important, obviously, toward housing equity, is fair and equitable housing outcomes. I actually wrote all of the language that's in these sections, partly because every single word was thought of, and it was very hard to ask these questions, partly because we don't have a lot of data in some of these areas or ways to measure, are we making an impact? But what we do know is that communities of color are not doing well. And every time we look at wealth over time, or access to housing, or homeless statistics, we see communities of color are falling behind. And it's not them that's falling behind. They have been purposely and systematically excluded from wealth creation, from access to housing, and it's showing in the numbers. And so right now, the best attempt we can give it at this level is to ask cities to answer a series of questions. And so this is more qualitative, but essentially requires cities to think about what they're doing when they're coming up with these strategies, to see if they are addressing these very important issues. So the first one we have is location and transportation. We wanted to link this to our climate friendly initiative. So how is the city striving to meet these greenhouse gas emissions? We could have just stopped there, right? But really, it's about of the protected classes, right? We just wanted to make sure that housing for people who have been historically marginalized aren't put in places where there's more environmental pollution and more environmental justice issues. Then there's the fair housing issue. And as Allan said, there hasn't really been a link between fair housing and zoning. So this brings that link. How is the city affirmatively furthering fair housing for all state and federal protected classes? And then a definition of what that means. A lot of that dealing with access to housing opportunity, and areas of patterns of integration and segregation. So cities can look at their zoning and see how those patterns are forming out. Housing choice. How is the city facilitating access to housing choice for communities of color, low-income communities, people with disability, and other federally protected classes? And then what is that? What does that mean, housing choice? It sounds great, but we had to define it. And so located in neighborhoods with high quality community amenities, schooling, employment, business opportunities, and health and safety environment. We know that the quality of schools is tied to the neighborhoods that you live in. And if you don't give access to federally protected classes to these high quality, wealthy neighborhoods, you also don't give access to schools. And what's great about Richard Rothstein, and when he's going to talk, is he came from education background and suddenly realized education is so tied to housing, and education and housing are so tied to your future prospects in life. And then homelessness, very hard question to address within the context of zoning. But so this is more qualitative. How is the city advocating for and enabling the provision for housing options for residents experiencing homelessness? And how is the city partnering with other organizations to promote services that are needed to create permanent supportive housing? cities don't really necessarily exist in this sphere. And so really this is about partnering with organizations that do this work, but calling it out is a very important need. And then opportunities for affordable rental housing and home ownership. How is the city encouraging, supporting and creating opportunities to encourage the production of affordable rental housing and wealth creation via home ownership for these protected classes? There's a lot of emphasis in Oregon on rental housing. There's very little money and emphasis on home ownership. And I've been a big advocate when I was in the Portland Housing Center on promoting that. And that really goes back when you hear our keynote speaker today. He's really talking about home ownership because that's where wealth was created for white communities and was taken away from Black communities specifically. And then gentrification, displacement, and housing stability. That is really of huge concern that some folks have with regard to House Bill 2001. So House Bill 2001 doesn't exist within a void from House Bill 2003. And so how is the city increasing housing stability for residents and mitigating the impacts of gentrification? So all this redevelopment is going to happen. What about the folks that are currently living in affordable housing that might get displaced? The department is currently coming up with the toolkit. And when I say that they're coming up with it, they're actually looking to the experts in homelessness and housing stability at Portland State University to come up with the toolkit to assist cities in making sure that they pick some of the strategies that can help with gentrification. And so as a real estate developer, I very much said, you know, we can't oppose new development because of fear of gentrification. What we need to do is promote new development at the same time as creating the tools, resources, money, whatever it takes to help people in these communities make choices and be able to live where they want to live. And also have housing, have the ability to be redeveloped, and so it doesn't become deteriorated. Desired outcomes of this approach is, first we're going to understand the magnitude of the problem. I think we all know it in theory. We're going to have numbers to go with that. We need cities in Oregon to be pro-housing. As a developer, it's very frustrating when you go to a city that's supposedly about housing, and then you go through the process and realize the city itself is anti-housing, and then we wonder why we have a housing crisis. We need to develop resources for cities to implement this work. This is hard work. So that hopefully this will come out of this process. And then housing production at various price points, right? That's the ultimate goal. Housing for marginalized people, that's super important. If we come out of this, we have to have that. And then reduction in discriminatory practices. We should not be the source of discriminatory practices. And then equitable housing distribution. Where is, you know, you're going to have all this great new affordable housing. Is it all going to be concentrated in one area, or is it going to be in areas with, let's say, good schools, like we said before? So House Bill 2001 is going to help with that, but really this regional needs analysis work needs to be done to effectively allocate the need of affordable housing throughout all communities, not just in some areas. And then the ability to measure progress. We need to know that this worked. I constantly told people during the process, we're going to make mistakes. We have to acknowledge that, and then we got to pivot and do better over time, with the ultimate goal, obviously, of meeting our housing need. So I want to thank you for letting me speak on this topic. That's very passionate to me, and I wanted to thank all the people that you saw on the list that were involved. This is not a one-person effort. This is a whole statewide effort, and we need everyone involved with this work at every level. So I encourage all the participants to volunteer your time to make this happen. Thank you.
Yeah, thank you so much for that. And I want to transition straight to Judge Bucksbaum's presentation. We've got some great questions already populating the Q&A. And I've got some questions from presenters in the chat. So we've got a lot to talk about when we get to kind of the open panel portion as well. But I want to just, without further delay, transition to you, Judge Bucksbaum, so you can share your screen and unmute and share your video. So Judge, I can see your screen. I can see you're unmuted. I don't know if you want to share your video or not.
Yeah. Not that I'm much to look at, but okay, here I am.
Good to see you.
In Western New Jersey. Now you may wonder, I once said when Miriam asked me to appear in something in Connecticut, I said, I began my remarks by saying, I'm from New Jersey and I'm here to help you. And it brought down the house, but we have learned a few things. And I would say, to pick up on Allan, the New Jersey Supreme Court has gone where no court has dared to go before. Our early history, I'm going to divide this talk into three parts. And you can see the slides were developed by the Fair Share Housing Center, so I'm relying on them. But I have a whole bunch of things that really don't depend on the slides. The early history of the New Jersey Supreme Court was not promising. We were among the first courts to approve large lot zoning, exclusion of apartments, exclusion of mobile homes, and that was our trajectory well into the 60s. But what happened in 1962 was Justice Hall asked the Richard Rothstein question, which is like, what are we doing here? And Justice Hall was a conservative Republican from a very wealthy portion of New Jersey. He's so conservative that when I appeared in the court before the court in the 1970s, he kept asking me why I put down the ACLU of New Jersey as my office address and not some law firm. But he did see the issue that Richard Rothstein raised, and he protested in a vigorous dissent in 1962 the exclusion of mobile homes. A mere 13 years later, he was in the majority for a unanimous court, and the court held that housing is a right and that it's a misuse of constitutional proportions for the zoning power to be used to exclude people of low and moderate income to the extent of the region's fair share. This opinion was initially poo-pooed. There was resistance. So in a relatively short period later, in 1983, the court came down with Mount Laurel 2, which said, we're serious this time. We're tired of seeing studies. We're tired of seeing litigation. Everybody's got to step up and develop a realistic fair share housing plan that actually works. And we're not going to tolerate the evasions that have occurred to this point. The legislature reacted vigorously because the builders were starting to have a field day coming in and throwing out local zoning. And they adopted a statute which provided for a mediation process. And surprisingly enough, this statute, because of the court's impetus, actually worked for a while. But then it slowed, and I could say it slowed under both Democratic and Republican administrations, to the point where in 2015, the court said the agency is doing nothing. The courts have got to resume control. I attended that oral argument, which led to what we're calling Mount Laurel 4 in the slide that you see at the slide number 10 at the bottom. It was really embarrassing. The agency had no plans to do anything. There was a conservative justice who kept on trying to say, and in fact, you're going to do something someday, aren't you? And the poor deputy attorney general kept saying, no, we're not doing anything. So the court unanimously agreed that the cases had to go back to the court. And what the court did was very unusual. The couple of unusual things about New Jersey to start with. We have a very strong Supreme Court. It's not elected. It's appointed. It has a tradition of activism. And initially that activism was on behalf of municipalities, but then that changed. But the other thing we don't have are unincorporated lands. So it's possible to take our 565 municipalities and devise a system that covers each and every one of them. There were no milpitas or blackjacks that are possible to be created in New Jersey. It is possible for the court to get jurisdiction relatively easy over every ounce of land. The court divided us into the 15 vistinages and assigned a judge to supervise each, the Mount Laurel compliance in each of them. But maybe its greatest innovation was to require that the Fair Share Housing Center and Advocacy Group was a permitted intervener in each and every case, and also to require the input of a court master, usually a planner, in some occasions a lawyer, like myself, to supervise the development of the plans to make sure that by the time they were actually reviewed by a court, they did something real. And I can't tell you how important that having that advocacy group, the Fair Share Housing Center, present in each and every one of them, the 330 cases, what a difference that makes, because they have the expertise, they have the wherewithal, and they have the clout to make sure that the plans are not just make-weights, but actually have some reality. And so the next major thing that happened when the court returned the cases was that we had to settle the numbers. What's the fair share? What is the total obligation for the state going to be? And a decision in Mercer County involving South Brunswick Township, the court assessed a very substantial obligation. You can see, although this is a little small here, you can see from Mount Laurel, the total obligation in the Mount Laurel Township itself was 820 units. So these were real numbers, and some towns that had had very small numbers suddenly found themselves with substantial numbers, even if they were in semi-rural areas. So everybody had to figure out what to do with a real obligation, and with some real teeth in the enforcement through the courts, the Fair Share Housing Center, and the court masters. I think the court strategy was wise. So let's go into part two, the results, the techniques and the results. And I was listening to the commissioner talk about the different options. And what the court has done is tell everybody, you've got a substantial obligation, we're going to supervise it. But the court has been relatively, let's say Catholic, if Ed doesn't mind me using that term, in allowing different techniques. So even in some of the smaller towns like I've been the master in, we've seen an amazing variety of techniques. And I'm going to just go through this list here that I made up. Housing developments with a portion of units set aside as affordable. And these have to be both rental and for sale. Actually, we had more of a problem getting rentals in. So there's a minimum 25% obligation for rentals. Adaptive reuse of uneconomic office space for housing and retail. Reuse of former sites for hospitals and other facilities like quarries. Public-private partnerships involving redevelopment, where the redevelopment now has to include a component of low and moderate income housing. And that is a way of making sure that towns that are built up also contribute to the development of affordable housing. Deed restrictions, buy down, write down, placed on existing multifamily dwellings. So the town might buy a home or a 2 or 3 family unit and establish a deed restriction with a controlled price. Conversion of former senior citizen developments, which were the towns were happy to approve because they involve no school children and God forbid any minorities, but now many of them are being converted to Mount Laurel type affordable housing. Overlay zones to ensure that reuse of occupied sites in general would include affordable homes. Use of housing, we have requirements for trust funds, 1.5%, 1% for residential, 3% for non-residential, and higher in the case of variances. So these trust funds, and there are substantial funds in them, can be used for the development of housing. Let's see. These funds have been used for as many as 70 or more rehabilitation units in some of the older towns. Development of alternative dwelling units, like towns can have up to 10 accessory apartments. And some of the towns, like the one in which I live, are actually able to do that, provided that they're subject to deed restrictions. And finally, yes, towns can build housing. Many of the towns, as an alternative to the 4-to-1 set aside, have preferred actually to develop affordable housing. They're required to come up with concrete plans, name specific developers, name specific timetables. But we have a lot of towns that have actually gone into the housing business, maybe not through municipal forces, but through RFPs or requests for commitments. So that's actually been an important part of our process, as well as the private developments. So that's been a critical. So we have a variety of techniques. The other thing we're doing, and you can see this with the presumptive barriers, and I commend you to look at the regulation NJAC 5:93, which sets forth some of the minimum densities, 6 units an acre in general, for housing, and minimum set-asides and depending on the density, 20% if it's 6 or more, and somewhat less if the densities are lesser. We also require that the sites will be real, this approval, available, developable, suitable. We originally had things like the original Mount Laurel case. They zoned something that would never be developed. And although, this has not been a perfect result, the sites have to show the master and the Fair Share Housing Center, then the court, that the sites are real. We also deal with gotchas. No gold-plated development standard, costly impact fee, fast tracking of development. And you'll see that's in 5:90.
Sorry, you asked me to interrupt you at 5 minutes, so.
Okay, 5:93-10. No escrow fees. No oversized sewer water lines. So all these requirements have to be met, so there are no end runs about the requirements for affordable housing. And there's a procedure where you can go back to court. The court will intervene if a town drags its feet, and that's actually happened. Towns have then been subjected to the builder's remedy. Not many, but a few, at least 2 that I could think of. So what's been the result? Under the original Mount Laurel case in the Fair Share Housing Act 52:27D-301, there were 65,000 units developed through the year 2000. The projection now for 2020 through the year 2025 through the existing settlements is another 50,000 units. And you got to believe that the number in these suburban towns would have been close to 0 if it were not for the push. Now, Fair Share Housing provided some interesting statistics about the distribution of these units. New Jersey is #1 in the decrease in units, in 100% affordable units in highly impacted poverty areas. It's #1 in the increase in units in areas with 10% less poverty. And it also has the least number of tax credit units going into poverty impacted areas. I commend you. This study is cited by Rothstein, among others, Douglas Massey et al. From 2013, Climbing Mount Laurel. And it's an intensive study of the results of the Ethel Lawrence homes, which were a prototype of 100% affordable housing built in Mount Laurel itself, which, by the way, just was rated the 16th most desirable town to live in the country by Money Magazine, partly because of its diversity. So no tax effects, no bad effects at all, and the effects on the opportunities for people who've actually lived there, who might have otherwise been growing up in Camden, have all been positive. So the results of that study, if anyone's willing to listen to it, which is unfortunately not often the case, have been all positive. I would finally mention 2 things. we do provide for a range of affordability. And just to give you a quick example here, you can see these affordable developments. The rents in the Princeton area, $580 to $1,160 for a 1-bedroom, and $804 to $1,608 for a 3-bedroom. That's in probably the most desirable area in the state. We do require a range of affordability from 25% all the way up to 80%. So 37.5% from below is the target, and about 67% for moderate. So there's no skimming. And you can see the results from Massey and other studies. This one slide is very, very typical. Now, obviously, it's not nirvana. We didn't do nearly the number of units that the fair share statistic would have provided. Some parts of the state, like the Highlands, have an environmental carve-out. There were multiple decision points, and the DEP, or Environmental Protection Agency, has not exactly been cooperative and has denied permits to some of the Mount Laurel developments. I can't say that the amount of racial integration that's taken place is enormous, and certainly these developments don't address homelessness. But in terms of the underlying obligation, as my friend Carl Biscayer said way back when, Mount Laurel keeps the responsibility to poor people on the agenda, where it otherwise might be forgotten. And in that sense, what Justice Hall started in 1962 is still very much the point in what we're doing in New Jersey. And I'm glad to have spent a lot of my career. I started when my age had a 2 to begin with, and now my age has a 7. But if you got to be 75, it's at least nice to be able to look back on this kind of activity for all those years. Thank you very much.
Thank you so much, Judge. If you could stop sharing your screen now.
Okay.
Wonderful. And I'm just got this. And so, we have, a full 15 minutes, which is just fantastic for Q&A. I've received questions from panelists in the chat and from attendees. And I think I'd like to start. Allan, you had a question, I think, for each of your co-panelists.
Yeah, thanks. I think Judge Buchsbaum, you addressed it, but in reading about the Mount Laurel Doctrine and the work that you all did, and you said that the court did go boldly where no one has gone before. Was that work as revolutionary as we think of it, as you all were proceeding through it, and what you were trying to accomplish, especially legally?
From a legal standpoint, it is revolutionary. Whether it changed things on the ground in a revolutionary fact, that's a harder question to answer. It certainly has changed some things. You do have affordable housing in some of the fanciest areas in the state. If you ever go to the junction of 78 and 287, you'll see a huge development with hundreds of affordable dwelling units that never would have taken place but for the court's intervention. There's no other state that has gone this far as a combination of real numerical goals combined with actual standards for achieving those goals. So, as the Supreme Court said in Mount Laurel too, we can't build the house, the courts can't build the housing, but we can do our best to provide opportunity.
Is there a way to spread that to other states? I guess I'm hearing what you're saying, exactly that I would think that the Mount Laurel Doctrine should be more widely applied. And I don't know that I'm hearing that.
Well, that's why I said our courts are not elected. Could you imagine being up for election when Mount Laurel is an issue? And that's one factor. And the other is our tradition. We were one of the first consumer-friendly courts. We overturned caveat emptor long before other courts did. So there was a tradition here of doing stuff. I wish the doctrine did spread more widely. Some other states, Connecticut, Massachusetts in particular, Rhode Island, have adopted builder's remedy statutes. The American Planning Association and its Growing Smart project developed a builder's remedy statute, which I helped draft. The models are out there. I think it takes advocacy. And Oregon, well, we just heard from the commissioner, Oregon's done quite a bit. And California's recently made some moves. So I think advocacy on the ground in all these states, you know, you wouldn't have gone to what you did in Oregon without people like the commissioner and my friend Ed Sullivan, and I see Robert Liberty's on there and a whole lot of other people. And Dwight Merriam in Connecticut. I mean, it's a state by state fight. I think Illinois has done a few things. So it's a matter of carrying the fight.
Yeah, thank you. Yeah, and Vice Chair Hallová, I wonder if you want to respond to that at all about, about how it's been in Oregon to move that fight forward. And the question I actually had was the same thing that you had pointed out that I did around. It's sort of remarkable to me that these connections between sort of fair housing and racial equity haven't been made in zoning prior to this. I mean, they have sort of in the housing development world, but less so in the planning and zoning world. And it seems like those things should be so closely married.
Yeah, I mean, first, I want to thank the staff at the Department of Land Conservation and Development. I thank the legislators. I thank the stakeholders that are involved. And like at the end of the day, the staff wrote all of this. So there, I just wanted to say that. Yeah, I think, you know, part of this problem that goes back to the history of racial segregation and the history of racism in our country leads to the fact that we don't have a pipeline of diverse land use leaders, right? And so in various places that you go, you might be the only Black person in a college program related to planning. So it's not, just like this reflects in every other industry, if you don't have people in place and you don't have diverse leadership, then the issues of that community aren't brought forward. And so like right now, what's great about the process we did at the state is we're taking the leaders we have and we're bringing them all together and doing that. But the future is really going to be dependent on a pipeline of young people, right, that see the need for this and make the connections. And land use has just been a very white dominated field. And that in the history that Richard talks about was very intentional, right? And so I'm hopeful that, you know, for Black Lives Matter, I'm hopeful for 2020 that it brought these issues to the forefront so that all people can participate in making this, remedying the past. So I guess that's the only thing I could think of why they're not connected. The people are not in place to make the connections.
Thanks.
You know, I just would say I want to just thank you for that response, and also to provide maybe a point of hope. So I'm teaching land use law right now at the University of Oregon School of Law, and my class is bursting at the seams. I've lifted the cap a couple times. So, you know, seeing land use be this exciting topic for law students, and it's also, you know, it's getting more diverse in terms of the interests. Of course, we also know that law schools have disproportionately large white student bodies and faculties. So there's a lot to continue to work on and to overcome. But I think that there is interest in young people in a way that I hadn't seen before. And also a demand by the student that we discuss and critically evaluate the racist and xenophobic history of land use, and look at current practices as well. And so I do see that, and I'm hopeful to see that. And I also just want to, I don't want to take up too much time, but I think about Resmaa Menakem talking about how, addressing white supremacy in this country involves a lot of work for white people. And, so there's going to be this gap. Well, not even just a gap, until we overcome some of these issues, there's always going to be, schools, that pipeline won't really be there in a full and accessible way until we overcome some of these issues. So, I'm also really pleased to see a lot of white people stepping up, and I want to encourage even more. So we had some great questions from the audience and from other panelists on other panels. And this is actually just one question. The yellow is the question. And I just wanted to point it out because I think it fits with what Judge Bucksbaum was talking about a moment ago with, the issue of an elected versus an appointed for life state judiciary. And Ed Sullivan was pointing out that, the difference in the New Jersey state constitution as well. And this is talking about that kind of political versus, legal wisdom or reality, and asking about race-based remedies. So I'll just read it. I have a question about the political rather than legal wisdom of expressly race-based remedies. Affirmative action has public support in the abstract, but when it's described as an explicit racial preference or set aside, it's very unpopular even in liberal places. There's a reference to some voting down of such measures in Washington and California. And then it's some data for progress polls showing that upzoning draws more public support when it's framed as an economic opportunity or growth policy rather than as racial justice policy. And then in the question, itself, there's a reference to education, right? So is there a way to thread the needle by raising public awareness about the awful history of de jure discrimination in land use while pursuing policies that are race neutral and provide opportunities to all?
Well, I can recall just when Matt Worrell came out, Judge Higginbottom, the first Black African-American judge on the Third Circuit, congratulated Justice Hall on grounding the decision on economic discrimination. And that's made a big difference here. We do have class snobbery all over the place in our state and most every state. But the fact that the court never explicitly espoused a race-based remedy, I think has made it easier to sell the doctrine. I also have to mention, we've probably been helped a lot over the last year of settlements by COVID, because all the public hearings have been Zoom, and you just don't get the same outraged public showing up in the hundreds saying, trash this plan, we're going to kill you, planning board or township council. And that's a cynical observation, but I have a feeling there's something to it.
Well, I wonder if anyone, from Oregon would want to comment on that question of accessibility, via Zoom, since we have pending legislation now addressing that issue, not with respect to the angry mobs, but with respect to the accessibility to a more diverse electorate.
I kind of wanted to respond to the question.
Sure, absolutely.
In thinking that I don't, at this moment in time, I don't think race neutral efforts actually provide opportunity to all, right? Because it ignores the fact that we live in a race-based society that has discrimination based on race. So when you make it race neutral, then the results end up being not opportunity at all. And so that's why I'm a big proponent of statistics and numbers, because just like there was a lot of greenwashing, right? There's going to be a wave, it's not there yet, of equity washing, right? We did all the right things, we checked the right boxes. Oh, wow, the numbers haven't changed. I wonder why. So I think I said this during the rulemaking process, we have to be very explicit about what we're doing, so that even if we make mistakes, then at least we know what the intent was and that we achieved it or we didn't achieve it. When we're vague about it, then and the race-based policies of the past were really specific. And guess what? They worked. They worked. They created wealth for the white American class, and they created segregated neighborhoods. It was beautiful in the sense of working. In order for things to work, we have to be explicit. And then that's when the lawyers come in and talk about how to actually get that done within our context. But I think the opportunities of non-discrimination are great in theory. They're like kind of equality, right? We're all equal, yay. In reality, we have to go toward equity, where we realize some people are at a disadvantage. And then what do we do to kind of unravel that? And the idea that it's not a tiny pie that we're all sharing, that we're expanding the pie through this process, and that actually having the members who are least in our community thrive actually makes the whole community thrive. And I think, we saw that in the protest of 2020. People are like, this is awful. Some people are like, this is awful. And I'm like, this is what happens when we don't address this as a society. So we have to address these things actively.
Commissioner, I might follow up with you then. There's a question from the audience saying, you mentioned in part the issue in housing equity isn't just about access to affordable rental, but making home ownership more equitable to classes of individuals. And can you speak more on that, current program or the need for the ownership?
Yeah, I mean, it was a while ago, maybe 6 or 7 years ago. I was in Portland Housing Center, and we were like, okay, we need to raise the profile of home ownership in the state. I think now, and that's what I loved about reading Color of Law, it was just very easy to say, we're going to help the middle class gain wealth and have home ownership. And it was seen as a helping America grow in a way, right? And now, if you talk about it, you can see people's faces. It's a giveaway. How are we going to give them this reduced, piece of land and or building, and then they're going to sell it and make profit of it? Like, that's not good. And it's like, okay, so the white communities can do that, and it's fine. Yet when we come to minority communities, it's not fine. And so it's the same practice of discriminatory, practice is just changing its tone over time. And so personally, I feel like housing equity and justice deals with home ownership, because you can borrow against you can have a line of credit against that to pay for college. You can sell it and move to the next house. It's a way to have and store wealth, at least the way in the United States that it's set up, right? And then on top of it, when you have minority communities that actually get a little piece of that wealth, and then you have discriminatory practices on lending and reverse mortgages and all sorts of things, it becomes to take it away. So there's been a lot of negative things associated with, let's say, the Black community and having housing that's actually set us back. But if the system was set up to actually think of helping people, that is, to me, housing justice. So I think, to me, affordable rental housing is super important, but it's sort of a Band-Aid right now if we're really going to try to address long-term wealth creation, which, all the statistics show that Black Americans versus white Americans way lower, and that I read something that said, like, in a certain amount of years, it's going to be zero. I was like, okay, how are we making all this progress, and then we're not actually making any progress? So home ownership, yes, I'm a big proponent. I've been for quite a while.
Right, it's about land, right? And land tenure, home ownership.
Yeah, and in the history of Oregon, where Black people couldn't own land, they couldn't do real estate transactions. That wasn't that long ago, and it feels like it's the same today. Like, nobody says you can't own land or have transactions, but if you can't get a bank loan and you can't, then essentially you can't own land or do real estate transactions.
If no one objects, I think that is a powerful moment to end this panel. And also, we've gone a few minutes over. I believe it's time for a break. So, thank you very much to the panelists, and to the attendees. There's more questions in the Q&A that can be responded to in the Q&A.